let's dive into the world of homeowners associations. You know, a place where a seemingly simple vote about sprucing up the neighborhood somehow spirals into a full-blown legal hearing. This is a story all about how, even when you have overwhelming support, not following the rules to a T can completely unravel everything.
You know, this quote from the HOA president, Sandy Chambers, it really just paints the perfect picture, doesn't it? We're talking about a tiny community, just 39 homes. So this isn't some huge, faceless corporation. It's a volunteer board dealing with, well, the everyday stuff of neighborhood life. Totally relatable. But this story isn't about a leaky sprinkler head. Nope. It's about a pretty significant chunk of change. The board wanted to pull $30,000 from the community's reserve fund to pay for some major upgrades. Now, for any small community, that is a big deal. And the way they went about asking for that money, well, that's what lit the fuse for this whole conflict. See, they had two totally different projects in mind, but they presented them to the homeowners in a way that at least one resident felt wasn't just unfair, but maybe even illegal. So what exactly was on this controversial ballot? You have to understand, the HOA board had been working on these improvements for nearly 2 years. They did their homework, they got proposals, they picked out vendors, and now they were finally ready to ask the community to sign off on the spending.
Okay, so here's the breakdown. The board wanted to do two things. First, resurface the roads for $17,000, and second, replace the common area gates for $13,000. But, and here's the kicker, when the ballot went out, homeowners couldn't choose. It wasn't, do you want the roads, the gates, or both? It was an all-or-nothing deal. One single yes or no vote for the whole $30,000 shebang.
And would you look at these results? I mean, it was a landslide. A staggering 91% of homeowners voted yes. 32 votes for, only 3 against. With that kind of mandate, you'd think, okay, case closed, let's get to work. But this was really just the beginning.
So, fast forward 6 months after the vote. One of the homeowners, a guy named Daniel Mayor, files a formal petition. Now, he wasn't arguing about whether the repairs were needed. His whole complaint, his entire case, was about the process. He claimed that bundling 2 different projects into one single vote actually violated Arizona state law. This is a direct quote from Mr. Mayor at the hearing, and it really gets right to the heart of his argument. He wasn't trying to stop the projects from happening. He just wanted the board to do the vote again, but this time to do it correctly. He wanted his right and everyone's right to vote on the roads and the gates as 2 separate things. And this right here is the law he was pointing to. Arizona Revised Statute 23-H020-REL. And it seems pretty straightforward, right? It says a ballot has to list out each proposed action and let you vote for or against each one. On the face of it, it really looks like Mr. Mayor has a slam dunk case. But of course, it's never that simple. The HOA came back with their own argument. They were convinced their process was totally by the book, and their entire defense was built on a very specific, kind of technical interpretation of that very same law. So let's boil this whole legal fight down to what you see here. On one side, you've got Mr. Mayor saying the law is plain as day. Separate projects need separate votes. On the other side, the HOA is saying, whoa, not so fast. They argue that specific rule only kicks in for votes that happen during a formal member meeting. And since they did their vote by mail and email, they claimed they were in the clear. And that, right there, was the million-dollar question for the judge. Well, the $30,000 question. Does that rule about separate votes only count if you're all in a room together raising your hands? Or does it apply to mail-in ballots too? The entire case hinged on the answer. All right, now we get to the good part, the judge's analysis. This is where the administrative law judge had to put on their detective hat and really untangle the legal language to figure this all out. So, just to recap, the HOA is planting their flag on this one statute, claiming it's only for votes taken at a meeting. That's their whole defense. But here's the twist. The judge found something, a little phrase, tucked away right inside that very same law. A few words that the HOA seemed to have glossed over. And this little phrase was a direct link to a completely different law. These are the words that changed everything, notwithstanding Section 103708. Now, that's just fancy legal talk for, hey, whatever this section says, don't forget to check out this other law, because it's part of the story too. It's like a legal signpost, pointing you somewhere else for the full picture. And here it is. This is what that signpost was pointing to. Section 103.708, a totally different law from the Nonprofit Corporation Act. And what does it cover? Actions taken without a meeting, like a mail-in ballot. And guess what it says? A written ballot must set forth each proposed action and let you vote on each one. Boom! That one little phrase completely dismantled the HOA's entire defense. So, with the legal puzzle solved, the judge handed down his final verdict. He ruled that yes, the ballot was improper, but the real question was, what does that actually mean in the real world, 6 months after the fact? Okay, so the judge sided with the homeowner, Mr. Mayor. Check. The HOA had to pay back his $500 filing fee, and they got slapped with another $500 fine. But, and this is a really big but, the judge said he didn't have the power to actually undo the projects. And that's just the practical reality of the situation. Think about it. 6 months had gone by. The work was finished, the roads were resurfaced, and in the words of the HOA president, they looked magnificent. The new gates were up, the contractors had cashed their checks. You can't exactly unpave a road. Which leads you to this really interesting question, right? If the end result on the ground couldn't be changed, then what was the point of all this? Did this hearing, this legal win, even matter? And the answer is yes. Absolutely it mattered. It mattered a whole lot. Because the ruling was never really just about roads and gates. It was about making a point. That the process, the how you do things, is just as important as the final result. Those rules are there for a reason. They protect the rights of every single member, even the one person who disagrees. And you can't just ignore them because an idea is popular. So what are the big takeaways here? Well, for homeowners, it's a huge reminder that knowing the rules, your bylaws, the state laws, that's what gives you the power to make sure things are done fairly. For anyone on an HOA board, it's a critical lesson. Just because everyone loves an idea doesn't give you a free pass to skip the proper procedure. And finally, it really shows the limits of the law. A judge can enforce rules and hand out fines, but they can't always turn back time. This case is just a perfect snapshot of that constant tug of war between what's popular and what's procedurally right.